But yes, I should point out this is all being recorded,
Okay.
just in case, you know. Right. Okay. So when we adjourned, seems like a long time ago now, but we were on page 17, just about to leave that. So pleading fraud, not really a great deal to say about that, because the position is well, I suppose there is a great deal to say about, because our RPC is silent as to fraud. So this is one of those situations where maybe Rule 84 that we looked at briefly this morning does kind of come into to play to try to assist you in terms of what you should be doing. So if we looked, you've got both of the relevant provisions from the BSB handbook and the SRA handbook set out at the bottom of page 17. And I think essentially they're both saying the same thing, which is you need to make sure that you've got clear instructions to do that, and you need to have reasonably credible material to do that. So as you can see, the one is talking about reasonably credible material that establishes an arguable case of fraud, and the other one, material which you reasonably believe shows on the face of it the case of fraud. Now, I'm not personally seeing any difference between those two really, but I think we can understand it as basically being a two-pronged requirement: instructions from the client, which, as I'm sure you realise, is not normally a massive obstacle to overcome. It's usually a matter more of putting the brakes on than getting instructions to plead fraud, and then the material side of things. So I think it's just a question of appreciating both of those points and realising that the fact that those two sets of guidelines do make essentially the same point should be seen as acting as a brake on being over-enthusiastic to plead fraud. Tempting as it is, and I say that you're going to get probably a lot of encouragement from the client to plead fraud, because they will no doubt have strong feelings that they have been ripped off by this con artist that persuaded them to buy their business off them, or car, or whatever it happens to be. So it's really going to be a question more of kind of damping down their enthusiasm rather than trying to stoke it up most of the time. But there we are. Okay, so that's one of those rare examples where the RPC doesn't really address it specifically. Okay, page 18 then, advocate and the client. Yeah, so what you've got in your ethical requirements is a kind of blend, really, of some of the things that we looked at this morning, which lend themselves or speak more clearly to the kind of litigation side of life, and others are more kind of general and would apply to maybe what traditionally would have been seen as more of the role of a solicitor in terms of clients' everyday business affairs and dispositions and so forth. So just to remind ourselves then, core obligation to act in the client's best interests. And along with that, we can see that you've got to respect somebody's freedom to instruct advocate of his or her own choice. But we also need to make note of the fact that the advocate has a choice as well, whether or not to accept those instructions. And the RPC are pretty clear on that. So there's no obligation on a Guernsey advocate, no matter how appropriate the field of practice might be, no matter how much experience they have, etc., etc. There's no professional obligation on them to accept a case or a client. Okay, so it's their choice. It's all money, isn't it? Yeah. 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 Yeah.
And this freedom to choose, does that extend to duty advocates at the weekend day?
No, I think they're a different kettle of fish, really. Yeah.
And then that cop out of, oh, I'm sorry, I'm not legally trained to deal with this domestic violence offence defence would then allow you to duck out of that one.
We wouldn't be on a duty advocate. You only go on it if you're putting yourself forward. Physical duty advocate stuff, which is essentially criminal.
You don't know what's going to come up.
People don't put themselves forward unless they think they can do it. It's going to come up.
Okay. So that wouldn't then allow you to get out of that.
Yeah.
You basically have to do it.
Yeah, but the way it tends to work is that, there's a rota system. You allocate amount of roles to be there for that period of time. There were various reasons why you might not be able to do it. That's a practical and pragmatic reasons, and then there's normally a and of course they don't have to reduce that. They call their own advocates. Probably say there's not put it from outside. 3 o'clock in the morning when you're
Yes. Happy days. Right. So, let's get that back again. So, in our next paragraph, we see indeed, as Jessica was just saying, then there are situations where you actually must not accept instructions. And we might say that we've got 2 examples there. You're not competent to represent the client, or you can't exercise diligence. And diligence really indicates the need for time management, handling all of your different clients and obligations in a timely fashion. All right, free choice, that was something that we just looked at there. And the next section does kind of indicate that it does have to be a free choice there. So you must make sure that there's no improper influence, and that you've got a reference there to Rule 13. Instructions mustn't be accepted where a third party has stipulated that this advocate must act for the client. So that's what Rule 13 says in terms. I'm going to throw it out to you guys. I mean, it kind of seems that if I was someone that was covered by insurance for something or the other, the insurance company might want to kind of, I'm not saying take over the matter, but certainly take a lead, an enthusiastic lead in the matter, and might well be suggesting that we go for person X rather than person Y. I don't know. What do you think about that? Because it seems to me that's a third party.
But it does happen. So all the people have got cards, they will have their advocate firm. And in the first instance, the insurer will encourage you to go there, but it can't be a requirement. But it sort of happens almost despite that, because of course you don't do it for one man race and insurance, but for big expenses, so they tend to end up with insurers might they want to deal working with them less sincerely. But that's quite common. A very common exam question, something I'm really old, is when somebody comes in and says, my husband, my wife has to come and see me, and sort of that sort of requirement.
Okay. So what else do we need to note from that paragraph? Yes, you may receive instructions from a third party who is purporting to represent a potential client. And I guess, again, insurance companies could kind of come into that scenario as well. So you need to take steps, as it says, to ensure that this is a client-free choice. So they could certainly be advised, they could certainly be encouraged, but ultimately it ought to be their decision. Next paragraph goes on to something else that we haven't mentioned so far, referral fees. So as you can see, it's proper to accept a referral of business from somebody else, but you mustn't be rewarding them with a referral fee. And I think that's probably something fundamental that we need to be aware of there. So again, it's really kind of coming back to, as it says, their independence and impartiality. Yeah. So certainly, I think it's different for solicitors, but no, very much outlawed, certainly as far as the bar is concerned. I think for solicitors, they're prohibited. I mean, it's been a bit kind of 2 horses really, but that's definitely the direction that I think the solicitors are moving in, and certainly for the bar for several years. Referral fees have just been point blank prohibited. Yeah. I think, sorry. Okay. No, so I think that the biggest difficulty that one has is actually identifying when something actually is a referral fee as opposed to something else. So, for example, if you've got entities, they seem to kind of, maybe I'm not looking at the right websites these days or typing in the right search terms, but you've had people like Eddie Stobart Law, that basically would just I think they just had a kind of database of barristers that did public access work, and they, you email in or speak to a live advisor via the internet with whatever your problem was, and all they would do is basically kind of put you in touch with someone that they thought was a relevant direct access barrister. That was about the sum total of it. But presumably, I don't know, but presumably they were getting some financial recompense from somebody out of that. And if it was the barristers that were paying them, then that's looking very much like a referral fee. So things like payments for marketing and advertising, that type of thing, certainly as a barrister in England, you've got to be very careful exactly how you're organising that, so that it's not kind of the more work you send me, the more I pay you. Again, the concern with that really is client protection or public protection, because if I'm prepared to pay you a lot of money, or basically, I don't know, your fees, your level of remuneration increases the more work that you send me, then that incentivizes you to send me the work rather than send, say, Jessica the work, because you're going to earn more from sending it to me. That's not guaranteeing that the client's getting the best person to represent. And that's what ought to be happening. That's why referral fees are increasingly seen as not good things to have.
But it does happen. I don't know how it's because personal injury lawyers, so personal lawyers and your countrywide, if you're on if you get on their panel.
Well, you can have like a membership fee. You can have that sort of arrangement, or that type of thing. But if it's linked in too tightly, too explicitly to the more work you send me, the more I pay you, and it's not just a like per capita thing, but there's like an increasing scale, that type of thing. So that the referrer is somehow incentivized to send more work to A rather than B, financially incentivized rather than making an objective decision about who's the best person to take on this case. That's when you're going to start to run into problems. Okay. Right. So independence then, page 19. As it says there, freedom from external or adverse pressures. So the advocate should be disinterested as opposed to uninterested, which is also professional misconduct. So yeah, one way that we can guarantee that sort of thing is, it says contingency fees. We looked at that this morning, didn't we? Contingency fees prohibited as far as contentious matters are concerned. Gifts, always a hot topic. I'm sure we all exist from day to day hoping to be rewarded by a grateful client. In my experience, it doesn't happen very often. Maybe that's my experience. So yes, and the point then, we're coming back to, so we've got 2 points really there: independence, the independence of the advocate from external pressures, and also, if you like, what would the public think about this? This is doing kind of professional damage on a kind of broader scale there, really. But I mean, it's an interesting question. Bribery, gift. I mean, if you have a happy and grateful client at the end of the day, are they not allowed to express their gratitude in some pecuniary or other fashion? I don't know. Yeah. So as long as you've declared it, then yeah. Okay. Good. Yes, that was. Did that not end up in court? Yeah, exactly. Yes. Was that? No. But yes. Well, I think there was some question mark over to whom the ownership of the Jaguar belonged. Yes. Yes. Anyway, yes. Okay. So where are we then? Client's best interest. Well, this is kind of self-explanatory really, but I guess the key point from this paragraph is not taking advantage of a vulnerable client, and that vulnerability could be expressed in a variety of ways. Certainly, one might tend to think about it in terms of either being very young or very old, and the kind of issues that come associated with those ends of the age spectrum. But it could also be lack of experience. So they could be moving in a field that is unknown to them. They could just lack experience generally, or as it says, they could be suffering perhaps temporarily, perhaps longer term, from ill health, which is hampering their ability to make decisions, sound decisions for themselves. And obviously that's beginning to shade then into that next paragraph that talks about clients who are suffering with mental incapacity, which in certain circumstances at least may end up terminating the retainer. They may of course have somebody appointed to act in their interest, and those individuals could then perhaps take matters forward. Ceasing to act. Now I have to say my students on the bar course love thinking about ceasing to act. They seem to think that barristers are doing this around the country on a pretty much daily basis. I try to inculcate them with the idea that this is like the nuclear option. Certainly, it may be different here, I don't know, but certainly for the self-employed bar, the idea that you are going around just happily withdrawing from like what I'd like to call an income stream for these purposes seems to me ridiculous, but they all love the idea of withdrawing and dropping clients. So as you can see, it's not really a two-way street here. The client has absolute freedom to end the relationship at any time, although as it says, obviously there may be an issue around paying any outstanding fees. However, the advocate can only terminate the relationship for what the rules describe as good reason and on reasonable notice to the client. So query what constitutes a good reason. Well, obviously, again, if we think back to the top of the page and your independence from external pressures, if the client was attempting to force you or pressurize you into doing something that you thought you ought not to do, either because it was illegal or against your professional obligations, then I think that would be a good reason. A more specific example there, in a contentious matter, asking the client to pay a reasonable sum of money on account of costs, and if the client refused to pay that sum, then that would be a good reason authorising the advocate to terminate that relationship. Also, coming back to something that we looked at earlier, if you can't represent the client competently, or because of other time pressures, competing time pressures, then you should stop acting for them in the story and alert them to that fact, of course, and let them find someone else with a little bit more time or just a more effective and efficient practice management. Yes. Strangely.
Your fees rather, you can get yourself into your and that so people have important here where they previously picked up their got themselves into a pickle, despite considerable unpaid fees by saying that. You've got to anticipate.
Yes, I think certainly the BSB handbook talks about not leaving your client with some adverse consequences, effectively. Yeah. Okay, so yes, when it's all over, as it says at the top of page 20, all of the material from the case should be delivered up by the advocate, but of course that's subject to any lien over the paperwork for the bill to be paid. However, there's a point about genuine dispute over costs that occurs both in this paragraph and the subsequent one. So if there is a genuine dispute over costs between the client and the advocate, and a new advocate has been instructed, then that lien should not be used to hang on to the papers if the new advocate needs to have them in order to have proper conduct of the matter. Okay. Now, looking at it from the other side of the fence, if you like, taking over from an earlier advocate, taking over from a predecessor, if you are replacing a former advocate instructed by the client, and as it says, the first thing you need to make sure is that that original retainer has indeed been terminated. And if there is an unpaid bill outstanding, then you shouldn't accept the instructions unless you can determine that there is this genuine dispute over the costs. So that's an interesting point where that phrase occurs into related situations. And as it says, for both of these reasons, it would be incumbent, really just a matter of professional etiquette apart from anything else, to contact your predecessor and inform them that you are now being retained by the client on that matter. And I guess the other point is, if it is a litigious point, then you're probably still, if you're the original advocate, you'll probably still be on the record until you've actually taken yourself off or applied to the court to come off the record as far as that's concerned.
You can't just put you're just
How do you determine whether there's a genuine dispute over cost? I mean, how do you do it in practice? How do you deal with it?
in practice, the regional act is something you feel popular, you haven't got anything to think about it. We haven't got anything beforehand, you have to be quite clear. The difficulty is that second applicant often starts doing things before it's established that it's actually a real issue. But actually, it's more a bit of a warning for second applicant. It's more than it might be. But that's a really good red flag. Unless it was a genuine thing that this person being tricky about things having to do consent, red flag, because actually, and you see clients moving around and then in court.
Yeah, I mean, this is not dissociated from the obligation, which we'll look at, I think, fairly shortly, to keep the client fully informed about costs, because at least if you're doing that, there's less likely to be a genuine dispute.
And oh my goodness, they own tens and tens, maybe £100, fees.
Okay, confidentiality then, still on page 20. Again, fairly self-evidently, clients' business and affairs must be kept confidential except as required by law. And you've got the example there of the Harrisongs Limited case. Can't remember now whether I had that on here or not. No, I don't. Or did I? Other one? Yeah, here we are. Okay. So, yeah, ex-party order obtained, arresting certain shares. So basically kind of freezing type of order there. And ordering the advocate who was acting for the defendant who owned the shares to disclose their whereabouts and other associated information. And the advocate applied for that order to be set aside, claiming that it was privileged, legally privileged information. Deputy bailiff did indeed set aside the disclosure order. However, taking the view that it was more a matter of confidentiality rather than privilege. Various authorities being referred to there, but as you can see, the claim against the defendant was respected monies due under a loan note. Papers before the court didn't disclose any breach of trust or wrongdoing on the part of D, so there were no grounds to order A to disclose the information required. Yeah. Yeah, confidentiality upheld by the court. And again, it's one of those situations where this is an obligation placed both on the advocate and the advocate's staff with a supervisory responsibility to make sure that the staff comply. So you can see there's a specific reference there to Rule 51, and that's essentially where we get the duty of client confidentiality from. It's not there in the initial stages. As it says, duty of confidentiality broader than simply not disclosing privileged communication, because it applies regardless of where the information has been obtained from. And you've got the example of Havlay Holdings that we looked at before lunch in a slightly different context. So I'm not going to go through that again now. Also, duty to maintain confidentiality is a continuing obligation. So not just through the lifetime of the litigation, if it is a litigious situation, or the lifetime of the retainer generally, but thereafter as well. So it's an obligation that you owe to former clients. But as it says, there are exceptions to this obligation. So 2 rules, 22 and 51, provide exceptions. So, and this kind of again comes back to a point that we did discuss briefly this morning, where the advocate considers that disclosure is necessary to either prevent a criminal act from being committed which he reasonably believes is likely to cause serious injury, or where he has information about sexual or other physical abuse of a child. It may be possible to justify disclosure if you see, if you like, the public interest requirements in that. And essentially what you've got, of course, with client confidentiality is really a public interest requirement. You can justify it in other ways, but essentially it's a public interest in making sure that, well, as much as anything, people receive effective legal advice, which they're less likely to do if they are in any way inhibited from being candid and frank with their lawyer. 2 qualities, as I said this morning, I would heartily discourage any client from being, but there you go. So you want them to give you information, to give you instructions, and if they are not reassured that there's a reasonable level of confidentiality about that, then the argument is they may be inhibited in that, so that people are not getting proper legal advice, which is not in a public interest. So you've got a public interest justification for having a rule of client confidentiality, and clearly in these 2 exceptional situations, you have other competing public interests which are highly persuasive as reasons for making an exception to the first one. So that's basically how that's working.
Even long after that person is now a client of somebody else's story.
Yeah, and again, I guess that's going to again shade into issues around accepting instructions to act against former clients, that type of thing. Yeah.
Have you already done conflict?
No. Bear that in mind then. Yeah. All right. The next point I think is so well known. There's really no need to consider it at all. But obviously, if a client does seek your advice on the best way to commit a crime, then that's not going to be something that's covered by privilege or client confidentiality. So there you go. Client care then. The relationship between the advocate and their client has been described, or is described in the RPC, as a fiduciary one. We can see a reference there to disciplinary matter, La Chambre de Discipline against an advocate from 2016. The bailiff said that the duties that are owed by both the advocate and his or her firm to their client are the same as the duties owed by a solicitor to their client, and referenced this House of Lords authority, Helton against Barker, Booth and Eastwood, which is one that tends to get trotted out quite a lot, certainly in English courts, in this type of situation. So as you can see from that quote, the relationship is one in which the client reposes trust and confidence. It's a fiduciary relationship. However, not every breach of duty by a fiduciary is a breach of a fiduciary relationship. Okay. So you can see loyalty, fidelity, core duties, including confidentiality. And in the 2016 La Chambre, which again I think we did look at very briefly, or mention very briefly this morning, the advocate or the advocate's firm was described there as serving 2 masters by agreeing to act for the lender and each of the 2 complainants who had previously been described as guarantors. looking to secure loans that were given to, was it, I think there were two sisters, weren't they? Were they two brothers? No, nobody's, okay, right, okay. So yeah, it's all right. No familiar relationship at all. It's just something I got fogged up in my mind with another situation, obviously. But as you can see, then the respondent's error, according to the bailiff, was to form the view that there was a complete identity of interest, so there was no conflict at all. When the reality was going to be that there was at least a potential for a conflict. Yeah.
It was bizarre.
Yep. Well, does that perhaps reflect on the makeup of the membership?
So the makeup of the was, I understand the decision, I don't know who spoke about that, but was a senior advocate who was based on his law practice, the lawyer who wasn't an advocate in the property world, and I can't remember this one. And then there's the non-advocate as well, who was the lay person, who must make sense to me. Yeah, listen to what happens carefully to what the experts say. But anyway, that's one of the main reasons why they found for the advocate in the first instance, was they didn't think there was complete identity of interest. And then at the appeal court, they disagreed. But it was a classic, and anybody's doing English solicitor about it. And when you sort of all those expert cases, that was never going to work. It seems to me there was never ever going to be a situation where this was because it was a classic situation when you've got the wife whose husband is borrowing for his business, and she's effectively putting him out and the family ownership. So there was always going to be.
One thought of the example in that case is the thing with that piece was the advocate who was at the shop or was referred to shop because it's due conflict of interest. Why the other advocate who recommended that his firm or her firm, why there was no sanction against that plan? So that struck me as almost like pushing it onto
It struck me.
partner. I don't know.
Like I got involved. It was something rather unfair in the sort of way that it was dealt with. The person who helped somebody get out of person, if you like,
Yeah.
But the other person, they didn't go after at all. Not at all. I don't know. That would have been the registrar's decision at the time. The registrar at that point, the original registrar dealing with the matter was Richard Oger, who signed the plan from the so for those of you who haven't looked at the case, there was a firm of advocates who were acting for the commercial lender, which wasn't an HSBC or anything like that, was somebody who taking a business lending a lot of money, and he had a commercial venture. He lent money to these two people who were wanting to prevent some of his premises, and the wives were the guarantors, and then the bond was taken out of the family home. When the wives needed independent legal advice, rather than going to another firm, the advisor for the business then asked his colleague who came and see the going to the wife, then which we do with this, unfortunately, I think the actually need to create a proper independent legal advisor, because there was such a risky, and indeed so risky, in fact, they did lose their head. So it was not just a theoretical risk, it actually did people was really due to their inability to actually pay that.
But the lender and the husband of the rules could be represented by the same.
And so
That's an exception.
So sort of the one with proper informed consent. Interestingly, when it was argued by the advocate at first instance, because he took the view that he had a complete vested interest, he said he didn't need anything.
Yeah.
But actually, he possibly, if he'd gone down with informed consent, I suspect
Yeah. Yeah.
done
Yeah.
arrested. Yeah, and there's also, I can imagine if I was in that, some suspicion, I suspect this is just a formality of put it down and
Mm.
who we're going to blame, I don't know. It's got to be the lawyer's fault. So, there's a sort of professional unfairness about it. Unfortunately, we're not able to do that. There is a conflict of interest as well. Interestingly, the tenant Marshall doesn't agree that you should watch outcomes, for example, two sides of conveyancing. But she said she doesn't see how we can do that even with the ability before it goes wrong.
Yeah.
Who's going to blame?
Yeah. Okay, so, well, talking of advice then, as it says, advocate has to be ready and able to provide frank advice. There has to be that trust and confidence between them. And it has to be clear who's taking the decisions. So, by way of illustration, then you can see this Holiday criminal case. Not at all unusual. Talking in terms of when it all goes wrong, who you're going to blame. So when there's been a conviction in a criminal case, obviously the defendant casts around for somebody to pile the responsibility onto. So in this particular one, he appealed against his conviction, and one of his grounds of appeal was how his advocate handled the defence at trial. And the Court of Appeal simply looked at whether the trial had been unfair or been made unfair in all of this. And you can see that one of the complaints that the defendant or appellant had made was about these remarks that it was said could have been regarded as unflattering to his client, but described as a legitimate exercise by the Court of Appeal. Remarks plainly intended to distance the defendant from being portrayed as a calculating and experienced drug trafficker. You can basically read kind of between the lines in this short quote that he was portrayed as some kind of complete bozo. Yeah. Which obviously he wasn't very appreciative. But anyway, there we are. So yes, decision to do this was taken with the interest of his client fully in mind. But hey ho. So and cross-examination, I think this is quite general really. Cross-examination regarded as really the province of the advocate to make the final decision about what to cross on, how to conduct that, how long to let it run for. Those sorts of decisions you can't defer those to the client. So yeah, Court of Appeal said that there was nothing that had been brought to its attention that would make the trial unfair. So you're going to stay convicted, Mr. Holiday. As we can see, there's another reference there, another appeal against conviction. So that's the Collins decision. Also went to the Court of Appeal. This was concerned with what was described as the defence advocate's failure to call medical evidence at the trial, contrary to the defendant's express instructions. Court of Appeal said that counsel's decision was a reasoned and sensible one, and the conflict between the appellant's recollection and counsel and what the evidence showed had actually happened cast considerable doubt on whether counsel had acted in contravention of the appellant's instructions. Now, with that in mind, it does then kind of raise a specific point about how you need to kind of protect yourselves. And that's something that it's relatively easy to kind of lose sight of, I think, when we're talking about professional ethics, because we're so concerned with what we have to do for other people or what we mustn't do to protect other people, that, you know, our own kind of self-interest takes a bit of a backward step with that. So, you know, these sorts of situations, it's so predictable that if it all goes horribly wrong and the defendant is convicted on a plea of not guilty, they are going to cast around to, you know, look for anyone and anything to peg a ground of appeal on. And if you're their lawyer, you're an obvious target for that sort of thing. So it's really important to be kind of crystal clear on what your instructions are. And if there's anything that strikes you as at all subject to, should we say, the benefit of hindsight, you know, retrospection, all that sort of thing, always, I think, quite a healthy thing to do. And I don't think clients generally object to this, certainly not at the time, to get them to sign off on particular instructions from them. I've been fully advised by my advocate to do X, Y, and Z, and I've made this decision to do this of my own free will, signed AMUG, dated, whatever date it happens to be. There's nothing wrong with getting to sign off on a note of, I've received full and frank advice on this point from my advocate, and make this decision of my own free will. Why not? I mean, it's not going to stop them from appealing and saying I had a useless advocate representing me, but it might, it might give them some pause for thought. It might cut out some of those assertions. And frankly, even it all does go horribly wrong, you finish up in the Court of Appeal with it, at least you can say, well, look, here's my signed insurance policy where the client said it was down to him, his informed consent, etc., etc. So
The thing that probably and the experience has been, client has said person A, advocate said person B, requested to be paid for attendance, and then put something for the other. But you should believe me because I'm not. It doesn't work like that. It used to work like that. It's long gone. So, again, I was protecting you as well. Particularly when it's tricky, but in fact, it's a matter of course.
That happened quite recently in the magistrates with the duty advocate covering and putting the plea to the defendant and him accepting the guilty plea and then actually disputing the basis of that guilty plea. So then the judge had to say, everyone out, you need to have something signed here, Mr. Advocate, so that you're protected.
Well, that was very kind
All right, so who's in charge? That's the question. Continuing with that thought then, as it says, if there's a change in the composition of the firm, which is not unknown, then the clients must be informed of that. So they must know who is day-to-day responsible, the status of that individual, as well as who is the responsible principal. You can see that there's a reference there to Rule 35B, list of specific rules where information must be provided at the start of the relationship. This requirement doesn't appear to be there, but my suggestion is that surely it makes sense to give that information as soon as you sensibly can. All right, in terms of information that is required at the start of the relationship.
One of the difficulties we have now is group partners. Really, they should have even though. Yeah, good question.
Yes.
I think group partner is just,
Oh, crap.
it's just a word.
Yeah, it's a label.
I think the first,
Sorry, we'll edit that.
yeah. I can't remember, I'm not sure it's the first firm, I think it might be.
We didn't have a group.
Is that right? Yeah.
But no, we don't do that. The reality is that most things the rules that were that you have to be a partner, you have to be an advocate. And so this group partner developed, even where there weren't really groups, or not, groups in two states, for example, a whole number of different firms and different jurisdictions, but nobody really talks to it. But what does need to happen is that the group partners, they do need to have somebody who's not really responsible for work.
But in the end, I think other firms picked up the word, but it doesn't actually mean anything, it just is a word, like in itself.
The other firms have.
Right. But it's just, I think it's kind of
The group partner is the partner. a partner who is a partner who is not a and if you like it to get
Mm.
Is there an issue then with the group partner being ahead of a department? Because then who's the
Well, in
admin?
theory, I know it's more that people have been group partners should have an advocate who is ultimately responsible for work because it is the advocates who are responsible for the partners and it's the employees or group partners, even if not actually employees, who will come within that umbrella. So they do need a good writing. So, for example, in our firm, John Rochester, regardless of that, your considered experience, requires somebody to normally be responsible for it in case you get to the end of the job. And everybody's friends.
Okay.
Is there any talk about closing that down?
Well, we can meet LLPs now. Yeah.
Do you need to, in your plan B letter, say this person that is in the health department isn't actually Nancy?
We have to say that every
Yeah.
we can't put it up on-
Isn't it sort of also implied to say you're an associate, that you're an the advocate? So I think
Yeah, you
non-
need to say not.
yeah.
Yeah, just on that point, things that are implied, you've got to be careful when you're dealing with lay clients because, of course, what's implied to us may not be at all clear to them. So yeah, particularly when it comes to labels. All right, well, sticking with the thought about information that should be provided to the client, you can see that one of the points that was added in after the original RPC were published is 35B. So at the start of the relationship, we're back to heavy emphasis on costs in 35B. So making sure, as it says, best possible information is given about the likely costs of the matter, including method of calculating the fee if there isn't an agreed fee, the fact that the client may wish to set a cap, so there's a maximum amount that they could be called on to pay, or indeed just setting up a flag. So when we hit 100,000, let me know, that type of thing. Providing regular updates, I think that's really important, just as a matter of professional service and courtesy to the client, really. But yeah, regular updates on costs. Providing interim bill to focus the mind, perhaps, as much as anything. Obviously, if it's a litigious point, then as it says, what costs would be recoverable. The fact that they will remain responsible for costs might end up having to pay some of those costs, even if they succeed in the litigation, because that isn't that unusual. And ultimately, a cost-benefit analysis. So, I don't know, any thoughts on how much detail that sort of thing should go into, really?
Well, I think the cost benefit is normally that difficult on the people of matter of truth and you have to fight against it. But it's not an in-depth matter, certainly not in a litigious matter, but getting them to recognise that whilst it might be a matter of principle that they're going to chase £15,000, it's going to cost them £30,000, they might be thinking, and what you tend to find is that people think it is fine as matter of principle, start really popping up with things and then
No. All right, interest. Well, that's fairly straightforward. At the top of page 24, clients should be informed at the start if they are going to be charged interest on unpaid bills, but they can, as it says, agree to pay that interest later. I don't know why they would, but anyway, they can do. Competent level of work and service, we've already thought about that. Obviously important to manage your time properly, so dealing with correspondence promptly. And we can see there's a specific rule on that, 56, that says that failing to do that may result in disciplinary proceedings.
common.
I'm surprised. So also, as it says there, although it's not in that list of 35B, because that's really all about, I think, financial implications, obviously you should inform your client at the start of the relationship that there is a complaints procedure for your firm. And I think it often strikes people as a weird thing. I mean, if I go and see my GP, I mean, I don't think I've ever had a conversation with a GP where they say, by the way, pleased to meet you, take a seat, go behind that screen, and whilst you're dropping your trousers, here's how to make a complaint about me if you're not satisfied with the service. I mean, I might put my trousers back on at that point and just leave, frankly. So, yes, right, yes. Only came in with a sore throat. Yeah. Okay. So, yeah, I don't know. I suppose that's the society that we live in these days. Yeah.
Isn't that complaining you to Archbishop?
Well, we were speculating that.
Yeah.
Good question. I don't know what they can say in
Yes. Yes, not enough of a flourish on you. All right. Okay. Well, something else that we've touched on. I mean, frankly, a lot of these things just end up being interconnected and kind of linked to each other. But holding out as an advocate. So it says it's not just who's got the day-to-day responsibility, but who that person is in terms of their status. And obviously, the key status is really being that of a Guernsey advocate there. So we've already thought about the register this morning, maintained by the greffier. So I'm not going to say any more about that. But as you can see, again, this is fairly straightforward and typical in a number of different legal systems. If you falsely claim to be an advocate of the Guernsey Bar, or otherwise describe yourself, possibly through websites, through business cards, through advertising, that type of marketing, anything like that. If you mislead people into thinking that you're an advocate, then you're committing an offence. To be noted, irrelevant if anybody was actually fooled by that and instructed you. So you're really being punished for the attempt, effectively there. Also, as it says, it's a separate offence if you are advising people on the law or drawing up a contract under the law of the bailiwick for somebody else, if you are not an advocate, a consultant, an employee, or otherwise being supervised. It gets us straight back to the point we were just talking about there. There are some defences, though. It's a defence to prove that when you gave the advice or drew up the contract, you told the recipient you're not an advocate. So it's not a defence to holding out, because obviously that's ridiculous. Told the recipient he wasn't an advocate or otherwise permitted to act in that way. It's also a defence for the person charged to prove, so there's an interesting example of a reverse burden of proof there, prove that the recipient of the advice knew or reasonably to have known that he didn't fall within any of those categories. Right, costs. I think this is really just unpacking some of those points that we just looked at from the listing 35B in terms of upfront information for the client. But so as you can see, amazingly, if you've agreed a fixed fee for your work, then you have to charge the fixed fee. Who would have thought? But if you've only provided an estimate and it later seems that you have presumably underestimated there, you have to tell the client at once. If you have neither fixed a fee nor provided an estimate, then you have to tell the client about the means by which the fee will be calculated. And that could be just the charging rate of the person who's got the day-to-day responsibility for the file. Clients they are allowed to place a cap on costs. That's fairly self-explanatory. But again, as you can see, if a cap has been put on and the advocate then exceeds that cap unilaterally, incurs unauthorised costs, and then whacks in a full bill for all of that to the client, that could be considered to be professional misconduct. Just as a slight aside, there are all sorts of different ways that within the rules of professional conduct talking about misconduct. Sometimes this is described as misconduct or professional misconduct or serious misconduct, or will be subject to disciplinary proceedings. There's not really a consistent terminology in terms of describing that, but I wouldn't myself suggest subject to any observation that Jessica might have, I wouldn't suggest there's anything specific that one could read in to the different terms, the different expressions that are being used. Really. I think they're all kind of red flags, essentially. So is that reasonable? Yeah. Okay, so yeah, clients should be kept up to date regardless of whether there's a cap or not. No more than 6. Sorry, Jasmine.
Distinguish between unprofessional conduct and professional misconduct, and they have to be very different meanings in terms of the sanctions that might get. So I think that's interesting. I mean, I'm not saying that in everyone's doing it, there's a distinction drawn, but I think that was necessary.
No, I mean, well, that's an interesting thought. I mean, if I find myself with time on my hands in the months ahead, then I might investigate that a little more and just see how that. No, it does sound like an interesting proposition. So I think it's worthy of further inquiry. Yeah. Okay. So all right. What else have we got then? Render interim bills. I think we've already talked about that. Final bill within a reasonable time of the matter being concluded. I mean, I don't know why you'd want to go for an unreasonably long time, but there you go. Enough information to enable the client to do what they want to do and think about whether they want to dispute the bill, have a complaint about what they're being charged for. As it says, if a bill is disputed, then you've got to be in a position to and then provide a fully detailed version. Mustn't take unfair advantage of the client by overcharging. And I assume that means by way of comparison with whatever information you've given to the client previously or published on your website as to what your method of calculation would be. All right, we thought about cost-benefit analysis. I think we thought about the recoverable cost as well. So I'm not sure that there's much else to say on that score. Tiny bit about the employed advocate there. So it may not act for a private client unless that happens to occur within the course of employment. So now, onto your specialist subject. Okay. Oh, yes, conflicts. So we've already, I think, hit the nail on the head about independence and integrity, not being subject to external pressures, not putting yourself in a situation. Now, this, I guess, is slightly new, but we did look at gifts earlier, situations where your own interests are in conflict with those of the client. So, as you can see, the fiduciary nature of the relationship demands the advocate is candid with the client where he has a personal interest, and that's not just he. We look at footnote 119, it would include members of staff or partners, other partners in the firm. So where anyone really in the firm has a personal interest in those affairs or could somehow benefit from the proposed transaction. So as it says, the disclosure is simply for the client's benefit, doesn't absolve the advocate from responsibility for ensuring that independent legal advice is obtained on the matter. Shouldn't be a secret profit. I don't think that needs to be considered any further, really. It should be obvious. Overcharging, we've already thought about there. And as I've made the point at the end of that paragraph, there's clearly an issue about what we might describe generally as insider dealing, making a profit from using confidential information that's come into your hands through that relationship for your own benefit or advantage. What else do we need to think about? Family relationships, or if the advocate holds some sort of office, that may mean, as it says, there's at least the appearance to an informed, reasonable member of the public about the advocate's ability to provide the necessary, proper and impartial advice. I think that's all pretty straightforward. Public interest dimension, yeah, public may get the presumably wrong impression about that situation. Gifts we've already thought about, but a little bit more flesh on that particular bone there. You can see if the proposed gift is for a significant sum, right? And as it says, that's either significant in its own right or as a proportion of the client's assets. Yeah? I'm not sure what significant in its own right means, probably significant to the intended recipient. Yeah. You want to give me how much? Yeah. Well, okay. So as it says, must tell the client to seek independent advice. If they refuse, then have no more to do with the transaction. So goodbye, £100,000 or whatever it is. Yes.
Absolutely not. I'm going to give it to you. Please give me.
Yeah, I'll even drive you there myself. Okay.
Other than saying, I recommend. Would you need to see it? Would you need to take the
I don't think you can take their word for that. It's pretty dogmatic there. I think you need some clear evidence that they had done that. Yeah.
It doesn't difference in the menu.
No, further down the track. Yeah. Yes. All right. So conflicts between clients. That's always an interesting one then. So I think we've covered all the different possibilities there. Multiple contemporaneous clients, an existing client and a prospective client, or an existing client and an ex-client. So you can see if it's current clients that are all locking horns with each other, then the advocate can't continue and neither can the firm, it is said by Rule 48. However, as you can see, exception to this, without causing any detriment to the bar's reputation here, advocate continue to represent one if the other one gives informed consent to that. And again, that's fairly common, really. Yeah?
Is there a
Yes.
Is there a nominal value? Or is it just kind of?
Well, I mean, it's difficult, isn't it? I mean, if it's interesting. Obviously the richer the client, then it would be a drop in their ocean. Yeah. Well, see, I mean, I guess that's what I'm saying. Obviously, Jessica's saying, well, maybe if the family of the donor of the gift is it significant for them? I mean, it might be. If I'd be concerned about a conflict of interest if it was a significant sum as far as the person receiving it was concerned. Yeah. Could it? Oh, I see what you mean. Yes. Okay. Yeah. Well, I think basically it's either one of but it's either one of those. There's no baseline. I think it's as much as it's about common sense, and it's really kind of if either the ordinary man or woman in the street or the ordinary batonier knew all of these bits of information, what would they think? Would they think that this was perfectly legitimate and nothing to get excited about? Yeah. Yes. We see always, we get this sort of thing because in the bar handbook, it talks about, like for example, entertainment. I don't think there's anything about entertainment in the RPC, but it does talk about receiving entertainment. And the bar students always get very exercised about what if you have this. I mean, they can dream, can't they? This fabulously wealthy client, and they've just won a tremendously important case that was possibly worth tens of millions of pounds. And the fabulously wealthy client says, well, yes, so we're all off to, they try and think of some highly expensive restaurant that they could be taken to. So would I be allowed to accept that? I usually say that you have to ask for a bacon sandwich from the greasy spoon around the corner. That would be, no one's going to raise an eyebrow about that. But you're never going to get the client in there, obviously. Okay. But I just didn't realise. Yeah, who knew? The Ritz, I remember that one. Yes, okay, that's good. No, all right. So, what else do we need to think about then? Even if the other client consents, I think we need to finish that point off. So, if you've got, let's keep it simple, say 2 clients, and there's a conflict between them, if you can continue to represent client A if client B gives informed consent, but as it says, even if client B does give informed consent, then you still have to basically take yourself out of that situation if you've got relevant brackets confidential information about client B. That information was obtained whilst acting for client B, and it's confidential. So basically, informed consent cannot override the fact that you've got access to confidential information. You have to, I guess, do the right thing independently of the client's wishes. Little thought there about crime. So you may well, as it says, start by representing a number of defendants in the same proceedings. A time may come when one of them decides to cut loose and become a prosecution witness, plead guilty, testify against the other guys. And as it says there, it's hardly conceivable that you could carry on representing the guilty one and the not guilty ones. It's barely conceivable that you could carry on representing the not guilty ones. Probably quite easy just to represent the guilty one, do a plea of mitigation and call it a day there, really. But as you can see, others consenting is again your get out clause there. But again, the sting in the tail, if you've got relevant information about one that's confidential, that should be disclosed to the other client because you're acting in their best interests by disclosing that information, but you can't because it's protected by confidentiality, then it's time to get the bus back to chambers or the office. Yes, okay. All right, there's just a little illustrative case there. Solicitors Regulation Authority against H. Don't think there's anything that needs really to be identified about that. If you've got conflicts between people that are not yet your clients or between someone who's not yet your client and the current one, the rules say this is easy. Don't take on any new people. Yeah. So if there's a conflict between two perspectives, don't act for either of them. There's a conflict between a prospective and an existing client, don't act for the new one. So it's fairly straightforward, fairly simple. Yes, I don't think there's we've already mentioned the Barker, Booth and Eastwood case. I say it is one that is kind of classic case that tends to get trotted out in these sorts of ethical discussions. I'm not really going to say much beyond referring you to that quite lengthy quote there, except just to make a point, because I realised when I was looking through it yesterday that maybe I haven't given you quite enough information. So if we just kind of read through that opening bit, quoting from the judgment of Lord Justice Scrutton in Moody and Cox, where a solicitor had admitted to not disclosing significant information to his client, that's what's being referred to when the quote actually goes on and says, a man who says that admits in the plainest terms. So a man who says that he has not disclosed significant information to his client has admitted in the plainest terms he's not fulfilling his duty. So it just occurred to me that that perhaps was slightly unclear as a phrase. A man who says that admits. Yeah, says what? Yeah. So that's what that refers to, admitting to not disclosing significant information. All right, if we turn over to page 30, you will see there we work our way back or around to La Chambre from 2017. So as it says, certain specific transactions, if both parties give their informed consent, the advocate can act for both parties. So as it says, all situations where it's usual that a commercial entity is involved as at least one party, the other party typically is an individual. So Rule 49 is your basic provision there. So may act for both seller and buyer on a transfer of land, or for both lessor and lessee, or lender and borrower, provided the advocate obtains the informed consent of both parties to his or her acting. And as you can see, informed consent means consent given in the knowledge that there's a potential conflict between the parties. And indeed, not simply how your rights are being affected by that, but as it says, the advocate might be disabled from acting if a conflict arises, or from disclosing to each party the full knowledge that they have, or disabled from giving advice to one party, which is in conflict with the interests of the other. So I think it's quite a nice definition that one has got there. And you can see in the 93 case of Clark Boyce, there no general rule to the effect that a solicitor should never act for both parties in a transaction where their interests may conflict. Rather, the position is that he may act provided he's obtained the informed consent of both to so acting. Yeah, similar illustration in the Hardman and Hardman and Batiste case. So this is clearly not something that is unique or unusual. It's going to happen from time to time. Now, prospective client, so I'm on to page 31. Prospective client approaches advocate to act against someone, and the latter is a former client of the advocate. Now, what we looked at just over the preceding page was that where you've got a conflict between a current client and a prospective client, you don't take on the new client. Stick with your existing guy. So this is a variation on that. Now you don't have a current client, you have an ex-client and a prospective client. And obviously that's different because you're not earning any money at the moment, so you need to take on the prospective client. Yeah? But I'm being facetious, that is not the governing consideration here that distinguishes this from the other situation. It's an ex-client, but as we know, the obligation to maintain confidentiality is a continuing one that exists post-termination of the retainer. So if there is confidential information being held, there's a serious problem in terms of accepting the new client. Yeah. So, as it says, the obligation is continuing, but the advocate would owe a duty to the prospective client to make disclosure of all relevant information. So you're on the horns of a dilemma there. You can't please everybody. So as it says, you might suggest that one way around that would be to have an internal information barrier, what I used to call the Chinese wall, so that there are some people within the firm who have no knowledge of the confidential material, and they could start to act for the new client. Okay. As it says, not something that the way the current rules are drafted would seem to permit. Having said that, though, there is case law, and you've got an example there, Ozans, against Beetle Holdings, where it said an undertaking not to disclose may be a more effective measure than seeking a restraining order on the relevant advocate. I guess in part it would depend on the firm that was involved, maybe the size of the firm, how many advocates they had, how feasible it was to set up that type of structure. Anyway, you've got, as I said, a list of relevant considerations there.
That was part of the point. The courts have always erred on the side of resolve. And then in this case, that's the first time the court said actually you can deal with it. It's a full jurisdiction. If you have an advocate who has a reputation where there is an ethical law, and therefore the ship should be able to in this particular case, where information can be accepted.
Yeah, but by way of comparison, and trying to be discreet because I know this is being recorded, there is one of my favourite cases from Jersey where exactly this situation was set up within the firm. An advocate, we'll call him Advocate A, gave undertakings to the court that the internal barrier would be set up and would have nothing to do with it. And it then transpired that later on, a few months down the road, he had provided all sorts of bits of information and said, he'd just forgotten about the undertaking, didn't realise that he was trampling all over it. So that finished up in court proceedings. And the court should we say, took a very sensitive and delicate approach to that. Clearly had forgotten about his obligations and etc. Rather than kind of going, what the hell's gone on here? How could you have done that? But yeah. So when I take the point, absolutely, Jessica's makes, and we've got a little reference in the quote on page 32 to reputations about how easy it is to lose them. But from time to time, the wheels come off. Should we say that? Anyway, I have included the undertaking, so I thought it might be handy just to see how they were worded, how they were constructed there. Because these were effective undertakings, so the ones that the court was happy with. However, yeah, sorry. Mm.
In that one, there was a physical one particular case from one particular.
I think the Denny one was the one where Corey was coughing.
Yeah.
No.
Denny is the one where Peter was acting for a member of the firm who was getting divorced and therefore had access to
Yes,
children
yes,
of that
yes,
party.
yeah.
And then as the image was involved in contempt allegations and all the issues with that were there about her financial status, and therefore, we could have said that because he was acting for this particular partner, and he therefore had, as a term, more access to information about as the information he was a partner of.
Right. We've been going for what, just under an hour and a half now. Do you want to have a 5-minute break? Yeah. Yeah. We'll get ready for the final push.
Yeah, we've got here.
Well, I don't know whether I should say this because it might cause a sudden uprising, but I was told this morning that the charge doesn't apply to me.
No, so technically, you have this is all hearsay.
Yeah, yeah. But by reliable sources. So. Yeah, no. See, after she told me that I didn't have to pay this one, I felt so guilted out by that it was like I couldn't accept her offer. So. Or did I have to wait for her to go? I can't remember. Oh dear. Yeah, apparently the biscuits was the other side of last week's revelation. Apparently the biscuits in the airtight box out there are not provided for our benefit. I don't know who they're for, just for display purposes. Yeah. You haven't. Please tell me you haven't taken one.
I had a jam and gone.
Well, that seems quite appropriate. You counting them?
Huh?
You counting them? Yeah.
There's a new
Oh, steady.
They come all the way from London.
I see that Aldi, was it Aldi Christmas pudding has won the top Christmas pudding. Do you not have one?
No, not really.
Oh
They'll
wow.
never allow it.
Really?
You've got to wait shoes.
Yeah.
We go cut off.
I love it as well.
You're a horse
Yeah.
now.
Yeah. I love it. I'm going to wait tomorrow. His Kevin Morrison is not married for the website. Married one of them at work. Oh right.
Mm.
So working a small family. Yeah, working with we'll give you a small house of practice and
There you go. Yes, yeah. Way to go. Yeah. Didn't see that one coming. Oh dear.
That's what that's doing. That's why they were the safe way. The Morrison thought safe way. I had to get rid of the things. I
Oh.
remember acting on a case of big dispute with
Yeah.
Lions.
Oh, yeah.
They felt like they terminated their contract.
Well, that would cause a falling out, I suppose. Yes.
Yeah, I love Morrison. But when I moved here, here's a bit of chocolate. I went to Sainsbury's with
Step up, yeah.
Asda and Morrison's.
Well, now Staples gone down.
So we're going to Waitrose.
Oh yes, yes. So, better.
Wait.
Oh dear.
I mean, look, Aldi's obviously using the trick. It's got a captive market.
Yeah. The way you'll find it.
I bought it about 6 years ago, but I wear it all the time.
I say the numbers can't fit
I do, like yeah. They're a bit of a trouble, but I can't find them. I have got a pair of boots that I bought in 1998 that I still think actually look good. Really? That's what I thought.
Is this your band coat?
Yeah, I don't really knew how much they cost when I first bought it.
Really?
But the same about.
You took out what that about, can you?
Yeah.
Actually, I lost it. I didn't even know it. You should.
Value for money, eh?
I'm familiar. It just becomes a bit more difficult as it be at the second one.
Just make a decision.
It was good.
Yeah, the chocolate chip one. Yeah, these from before. They're good. I've been having a mince pie days, so it's.
Carry on. Well, it won my day till Christmas.
Yeah.
Wow.
You're not a single pound. It wasn't, no, I thought you. Yeah. I didn't even eat it. No, I didn't eat the whole bag in.
Sorry. All right, okay. Well, I'll keep an eye out when I go back tomorrow then.
The weather's so awful, but one of the things
It's very specific. Yeah. Brackets, not arc.
yeah.
Right, are we all back? Shall I start talking while you're munching? Yeah. Okay. All right then. So. Okay. Good. Right. So, yeah. All right. 1.6 practice management, page 35. I feel a bit diffident talking about this to you guys because I've never worked in a law firm. So the only person I ever had to manage was me. And I'm not sure I did a brilliant job of that either. So I happily defer to you and your own experience. But as you can see, just to really rub the point in, you're responsible for properly supervising staff, including these strange beings called consultants. So as it says there, well, group partner, I think we've already talked probably enough about group partners, but as it says, has to be made clear to clients that individual is not an advocate and will be supervised by one. Competent level of work and service, this is pretty standard as a requirement. So keeping the client properly informed, acting in a timely fashion, exercising reasonable care and skill, all very much speaks for itself. If you cannot act with competence and diligence, then you shouldn't be acting at all, really. So you should either not start, or if you have started, you should stop. Cost, we've already talked about. Complaints procedure, we've already talked about. Getting work. All right, that's something we haven't thought about so far. So there is a publicity code, which I believe is in one of the appendices. So as it says, advertisements shouldn't be misleading or inaccurate. And you can't do a kind of comparative exercise. So, compared to Mr. X, I am so much more successful, or either cheap or expensive, whatever you think is going to be the selling point, your USP. So we can't refer to a success rate or compare ourselves to others. You can pull in clients by name, as it says. So I guess that would be what in the form of a testimonial. Yes, my favourite advocate amongst the many that I've used on the island, something like that. Again, accept referrals of business. Yes, you can be a referral of business, but referral fees are out of the question. What else? If you are deciding to set up on your own, or you're pushed out, have to set up on your own, you can contact former clients and invite them to come along and instruct you all over again. Generally, that would be all right as long as you can make sure that you're not breaching your former partnership agreement by doing that. So some kind of like quasi-gardening leave, that type of thing, or just agreement not to poach former clients. Publicity code prohibits cold calling, so there has to be some kind of connection if you are going to contact somebody and ask if they would like to consider instructing you in your new position. Partnerships, we've already mentioned that a little bit, haven't we, really? And you can see the general rule is not with anybody that's not a Guernsey advocate. But as we can see there, it is these days okay to practice as a member or as an employee of a limited liability partnership. And again, I think that's in the study guide straight after the rules of professional conduct, if memory serves me correctly. You've got that provision there. Yes, so other points, Rule 37, sharing your fees, which I guess would include your profits. Nobody except other practicing advocates, in-house company that the advocate has set up, or an employee or consultant, a retired partner, or those who are claiming through a deceased partner. So those are basically your rules on partnerships. Okay, page 37, 1.7, mutual relationship of trust between advocates. Again, we've already kind of kicked a lot of this around earlier. Should be complete trust between the legal system and lawyers, as well as between the lawyers themselves. We're back to rule 1, not compromising the reputation, either your own or of the whole profession. And you can see reference to rule 71, which you've also got set out on the page there. Must act towards other advocates with frankness and good faith. Consistent, however, with the overriding duty to the client. So this is not an absolute requirement that is being imposed. You might have thought being frank was an absolute requirement, but it's not, because of course there'll be what? The duty of confidentiality that you owe. So there'll be restrictions on what you can say and do. However, as we can see in commentary point 1, being fraudulent or saying something that's deceitful, and deceit was something that cropped up in the 2018 La Chambre hearing. So there would be some kind of mental element involved in that. You'd have to be kind of knowingly making false statements there. Fraudulent or deceitful conduct will result in liability to disciplinary action. So if you've given your word, you must honour it, and obviously that would apply to things like undertakings. Yeah? And that's when either you've given your word personally, or another partner has, or any other member of the firm. And it doesn't matter whether it's written down or not. Good manners and courtesy, no matter how bitter the feelings between clients. I know that between clients because it seems to me, again, there's a larger, can I put it like this, a larger body of published case law in another quite nearby jurisdiction that gives me the impression that there are, let's just say, individuals who perhaps don't really embrace the spirit, or indeed maybe even the letter of that principle. Many times. Yes, that person. Yeah.
I would say
Would you?
it might not be
Okay, all right. Well, right, yes. Well, all right. Well, we see, we're back to what I was. Oh, okay. What, Humperdinck? No. Yes. Okay. Yes. All right. Well, obviously, you see, I don't know. Maybe this happens more here than I thought it did, because, like, point 4, an advocate must not write offensive letters to other members of the profession. So I'm not sure that principle exists in the code of that other neighbouring jurisdiction. So maybe it's more of a problem here. Yeah. All right. Okay.
Oh, yes.
Wow, the intrigue. I barely contain myself. Right. Okay. All right, undertaking. I did mention undertakings just now in terms of having to honour your word, or indeed the word of someone else in your firm. So you can see on page 38, we've got a section there looking at undertakings, and it does indeed form a discrete section of the RPC. Not obliged to give one, nor indeed to accept one. And that's fairly straightforward. You can do so verbally or in writing. You don't have to include the word undertaking or undertake. So it's really a question of what's obviously the intention of the should we say, utterance, spoken or written. Unequivocal declaration of intention. I say unequivocal. There may be conditions. So you can see towards the bottom of page 38, there may be situations where the undertaking is to do something that's outside of your direct power to have any influence over. But if you're given the undertaking, you're bound by the undertaking. So, think carefully before jumping into that situation. So, as it says, even to the extent it's not an excuse to avoid complying with the undertaking that you've given, to say that would require me to contravene my duty to the client. Well, too bad, you shouldn't have given the undertaking in the first place. So it may well be that you want to hedge it around a bit with certain conditions or caveats. Yeah? So as it says there, if the undertaking is made conditional upon a future event occurring, then as soon as it's clear the event will not in fact occur, the person who has received the undertaking must be so informed so that they can presumably take some action. Threats. All right, so we're getting nasty again. As it says, mustn't threaten another advocate with being reported where there's been a breach of conduct, but it's not a serious one. I don't think that means that you're okay to threaten people where there has been a serious breach of conduct. I don't think you should read it in that way. The advocate should put the other person on notice of a possible threat. Yeah, I think as far as that's concerned, that means if you are the apparent recipient of something that could be a threat, you should alert the other person that that's how you're perceiving their actions or their words. Says there may be an innocent explanation, but you should never threaten to report somebody in a way such as to put some pressure on them. Yeah. Okay. Oh, interesting. Oh, well, we could speculate on why that might be, but possibly not. Okay, so contact with represented party. This again it's almost a matter of etiquette, isn't it? Professional etiquette, really. So if you need to communicate with somebody, but you know that they've retained an advocate to act on their behalf in that matter, then you should be communicating with the other advocate So no direct contact with the other represented party. Two exceptions to that. So first, if you've written to the other advocate and got nothing back, then maybe it's okay to have direct contact rather than just, accept I've run into a brick wall on this one. And secondly, where for some bizarre reason, the other advocate has refused to pass on your messages to their client. But again, matter of professional etiquette, in both instances, alert your oppo first that you do intend to make direct contact. That may stir them into action, perhaps. Or they may go, oh, I thought I told you what happened. So, yeah, just alert them first, okay? Also, intriguingly, noted that the rule doesn't stop the advocates from suggesting to their client that the client makes direct contact with the opposing party. Yeah, as it says, there should be some tact exercised there, because if they are represented, they will have certain expectations about what the representative is meant to do for them, which would include perhaps things like communications from the other person. So you do need to be a little bit tactful about that. So if it's a non-contentious matter, of course, you may have no idea whether the other party is represented or not, or indeed if they are, who is their representative. So as it says, it's quite proper in that situation to contact the other party in writing, simply to ask if they are represented, and if so, by whom. Just practical, really. All right, access to an opponent's documents. This is a great ethical standby that we always love to talk about, and yet, as it says again, something that the RPC are largely silent upon. Yeah. So the only thing that I have ever found is Rule 57, which prohibits any action by an advocate which is fraudulent or deceitful, or which is in any other way contrary to their position as an advocate. So if you've stolen the other side's lever arch file, then that's clearly going to be what, fraudulent or deceitful, one would imagine there. But yeah.
The other side either losing it or destroying it.
Yeah, okay, all right. So, well, you can see there you've got rules. I've made reference to Rule 77 of the Royal Court rules. So Rule 77, where a party inadvertently allows a privileged document to be inspected, a party who has inspected may use it or its contents only with leave of the court. And as Jessica's just kind of indicated, that's not very often going to be granted. So there's quite a lot thrown in there, but I don't think it really kind of diverts back from the original point that as soon as you realise you've got something you shouldn't have been given, you give it back. If you are reading it, you stop reading it. If you haven't read it, you don't start to read it. It's as simple as that. Oh yeah, okay, so that's something else to think about then. Inadvertent disclosure. The court seemed to draw this distinction between inadvertent disclosure in the course of discovery and inadvertent disclosure at other times. So yeah, inadvertent disclosure during discovery and inspection. You can see that the court has accepted the principles set out in the Court of Appeal in England in the Al Fayed case. So, for example, in small 4 there, if you included privileged documents by mistake in the material that you've allowed the other side to inspect, it will generally be too late to claim privilege in order to then seek an injunction. Yeah. However, little 6, unless there's fraud involved, which we'll see doesn't normally apply, everything depends on the circumstances. An injunction may be granted if the documents have been made available as a result of an obvious mistake. And you can see in little 7 then, the mistake is likely to be held to be obvious and you'll get your injunction where the documents are received by a solicitor. Solicitor appreciates the mistake to be made before making some use of the documents, or it would have been obvious to a reasonable solicitor that a mistake has been made and there's nothing else about the case that would make it either unjust or inequitable to grant relief. However, small 10, the court is exercising an equitable jurisdiction, so there are no rigid rules. And paragraph 17, the court should do what is ultimately just and equitable. So, there's always, I don't know, I was going to say hope. There's always the danger that if you have screwed up, that will come back and haunt you, because they will start using the material and be allowed to use the material. Is this the Cengiz case? This one we've got here, 2011. Oh, yes, sorry. Yeah, sorry. Yeah, sorry. Okay, so yeah, inadvertent disclosure or mistaken disclosure outside of that whole discovery and inspection process, then the court has looked at a rather esoteric range of cases. I guess Ashburton and Pate for a long time has been the kind of leading case in England and Wales on this sort of thing. The Herbert Smith and the Mills and Reeve cases, obviously they're both firms of English solicitors, so you get the sense of what's going on there. Those are both referred to in the Bar Standards Board handbook as the kind of go-to authorities in terms of what to do where there has been inadvertent disclosure outside discovery and inspection. So I don't know, perhaps sending an email attachment to the wrong address, easily done. Okay. So, what else have we got? Yeah, I mean, you've got a fairly classic example here that on page 43, the court found that having found the material was inadvertently disclosed to Kerry Olsen and was confidential, it made a mandatory order. Well, which one is that then? I'm not sure that I've actually identified it. The court. Well, is that it? Is it in Ria Guernsey Trust?
Yes.
Okay. Well, okay. So judgment handed down in 2012. Anonymised version was not published until 2016. So this is 32 2016. Okay. Well, we got there in the end. That's footnote 179. 179. So yeah, that was quite a heavy duty order, wasn't it? Really, though. Yeah. So mandatory injunction: papers be returned by the opposing litigant, by their Guernsey advocates, by their English solicitors, and anybody else who knows them. All electronic records would be to be expunged from the electronic file systems at Kerry Olsen and the English solicitors and each of the liquidators' firms, including any records on their central servers, laptops, personal computers, or other electronic metadata. I don't even know what metadata is, but it sounds exciting. So yeah, real thorough house cleaning. Okay. Well, thank goodness they've settled everything now. So. Right. Talking of settling everything. Disciplinary procedures. Oh. So, page 44 then. As I observed earlier then, disciplinary matters and procedures to resolve them largely not included in the RPC, but there are various references to things going on. And you can see examples of professional misconduct as you scroll down through page 44. You can see references to disciplinary proceedings or exposing the evidence of disciplinary proceedings. Also, the phrase unbefitting conduct is used. I think that's normally the one where they kind of like rip your epaulets off and break your sword over their knee, throw it over their shoulder, that type of thing. Unprofessional conduct, we've also got that in the RPC. And a bit further down, you can see failing to provide the necessary information about costs at the start of the client relationship constitutes misconduct. So there's all sorts of different ways just in the RPC of describing where things are going wrong. And if we went back up the page to the second paragraph, we see professional misconduct doesn't have a definition in the RPC. It doesn't have a definition in the 2007 Guernsey Bar Law either. So it's very much, I guess, a matter of what? Practice, eye of the beholder, that type of thing. Okay, so I did make a note at the top of page 45. I don't know if Jessica can shed any light on this, that it does seem a bit weird that advocates are supposed to report professional misconduct and everybody else is meant to complain about it, I think. Yeah, no, okay, all right, fine. But there we go. As it says, then it may be this is a distinction without a difference. So maybe that's exactly what we've got. As you can see, then I've given you the way to complain. Write a letter along with your evidence to the president of the care of the bailiff's chambers. So away you go. 6 months deadline for making complaint, although that can be extended, as indeed it was in the 2018. Although interesting there, they did examine the decision there, because I think the president had said he'd considered whether or not to extend the deadline along with the batonnier, but the law only says that it's his decision to take. And I think the court suggested there that he might stick a little bit more rigidly to what the law says that he should be doing. By all means, have a consultation or a chat with the batonnier, but ultimately it's the president's decision there. Mm. No. Inquisitorial.
So when we did the 2016 appeal, and so one of the issues then was how do we go about that appeal? That again, no rules, that popular, he was rather sort of, and it was dropping the rules. So it is incumbent, and I think it's beyond reasonable doubt. They had
Yes, you're suffering from not having enough volume of throughput of material. People like misbehaving themselves allegedly. But yeah.
It's quite a brilliant. So I think they get a fair flow of people writing, but not that many of them.
No. Yeah, it's interesting that neither the rules nor the 2007 law would kind of make a distinction, which I think maybe that the Bar Standards Board handbook does make a little bit clearer, which is between, as you've just said, maybe issues around professional negligence, sue the guy, or the more disciplinary matters, or kind of service complaints, which should be resolved internally through the firm's own in-house procedure, really. And I think there is that basic tripartite distinction, but maybe these don't make that particularly clear.
I've been a member of the STROM now for about 4 years, and I've never but I do know that one particular advocate, one of the smaller firms, seems to be selected quite often. I don't know why not, but I'm selected conflict with it. I don't know how. There's quite a lot of stuff doing this.
Yes, interesting. Okay. All right. So, what happens when a complaint is received? Well, you can see on page 45 that the president of La Chambre and the batonnier will inform the respondent advocate. Obviously, they have to make a decision whether to refer the complaint to the registrar. And as you can see, if both individuals feel that the complaint is frivolous or vexatious or doesn't in fact raise an issue of professional misconduct, like maybe a service complaint, then it won't be referred to the registrar, and the complainant will get a letter telling them that. But it only requires one of them to consider the complaint to be valid, and then the battalion will refer it to the registrar, who then has very extensive powers to investigate, which do not seem to be fully utilised in the 2018 report, because I think the registrar is taken to task in a very nice way, and I think at the end they make the point that no one's really being criticised here, but these, there are ways to improve as we go forwards. Let's do things better. Well, I mean, if you're going to forward a complaint that, or an allegation that an advocate has misled the court, and then not actually asked the court to provide any insight as to whether they felt they'd been misled or not, you kind of feel that's a bit of an evidential gap, really. But, No. Well, again, there's an entirely. It's a fascinating judgment, I have to say. The point about suddenly introducing new arguments that you have not previously pleaded. So there's a lot to get your teeth into in that judgment, the 2018 La Chambre judgment. Also, I guess, if we move on to La Chambre, at the bottom of page 45, there are 3 members, as Jessica's kind of indicated, so layperson, advocate, and senior lawyer. Senior lawyer really effectively has to be an independent individual. Now, I don't know, the impression I got from the impression, well, that would be logical, wouldn't it, really? Yeah, possibly not popular, but the impression I got from reading the 2018 judgment was that the lay member was the chair. I mean, I could be wrong about that, but that was the impression that I had there. There was certainly a suggestion that the chair should be more proactive in giving directions and so forth, rather than quite passive, which comes back to Jessica's point about the court saying these should be essentially inquisitorial, which will, of course, place a bigger responsibility on the panel, and particularly the chair of the panel. I know there's with the equivalent body, with the equivalent body in Jersey, there has been judicial criticism of the fact that they have tended, with a similar kind of makeup as well, they seem to have tended to push the layperson forwards to be the chair, and that has relatively recently been criticised as not being likely to be very productive of an efficient set of proceedings being held, because they don't know what the hell they're doing, basically. So really suggesting that perhaps one of the legally qualified individuals might actually be the chair instead and try and drive things forward. But anyway, I just thought I'd mention that. Okay, so proceedings held in private, we know that, unless the respondent advocate requests a public hearing, doesn't seem very likely, and the panel or the chambre is satisfied that would be in the interest of justice. And we've already identified that one of the reasons for having a private hearing is because the lowest form of sanction is a private reprimand, and it's not very private if everybody knows about what's going on. What else? So significant powers to, as it says, compel people to attend, produce documentation. Evidence, as it says, may be given on an oath or by affirmation. The key point there is, I guess, is sworn. Simple majority, 2-1. Usual standard of proof, as Jessica's already identified, is beyond a reasonable doubt, unless it's proceeds of crime, where we slump down to balance of probabilities, thus making it, of course, easier to establish, or at least theoretically anyway. Not getting into any interesting points about different standards of proof, much as that might appeal to me. That's not why we are here this afternoon. So, decision. Yep. What? Beyond a reasonable doubt? Yeah. Yeah. Well, it's not that unusual, although again, I think I'm right in saying that both the SRA and the BSB have given thought relatively recently as to whether it's too high because it's not catching enough people, if you like. I think I'm right in saying that whilst the BSB, you'll be right back, whilst the BSB are sticking at the moment anyway with the higher standard, I think the SRA are going down, have gone down to balanced probabilities, much to the delight of all the readers of the Law Society Gazette, which I get delivered into my inbox. But, 'twas ever thus. One rule for them, another rule for us. Hooray! Yeah. So, yeah, I think generally they either have gone down or they're definitely proposing to go down for solicitors to just to balance probabilities because they don't think they're picking up enough problems, basically, or being able to address them.
So if you have a complaint, it comes down to a missing. Well, you can never reach it beyond reasonable judgment.
Yeah, of course, they're doing that all the time.
I think in England, the presumption is if they apply
Right, the presumption, but does it that enough? You wouldn't be able to convict someone on that basis. So,
I don't know, but
It's very rare that it's less than that.
it works very well for the adult.
yes.
But it just strikes me that after all this process, I have to take that question.
On the other hand, it could be
Yes.
for 51%.
Yeah. Well, then you see, you're almost, but not quite, managing to force me to start talking about the semantic difference between beyond a reasonable doubt on the one hand and balanced probabilities, where it's a very, very serious consequence for somebody. It's a distinction without a difference, really. It's what the English courts said. Well, it's only a balanced probabilities, but you require much more cogent evidence to get there. Yeah. What does that mean? Isn't that the same as it's a higher standard? Yeah. Anyway. Something else that I wanted us just to kind of be aware of, and if I haven't already encouraged you enough to look at the 2018 La Chambre judgment, this might just be the tipping point. One of the, I think, really interesting points there was it gives you a really good sense of, if you like, the kind of transitional steps from when a complainant writes a letter of complaint through how it then gets defined by the president and the batonnier, who refer it onto the registrar, and then it gets kind of refined again through the statement of facts that the registrar, if it gets that far, presents to La Chambre, the panel of La Chambre that's going to hear that. So by the time, I kind of thought to myself, when you're kind of reading through the appeals process and you're seeing, well, let's see, so the registrar can appeal and the respondent advocate can appeal against decisions. The complainant's just kind of like off stage, like, chorus off in the distance somewhere. But ultimately, by the time it's got to La Chambre, and then it's certainly by the time it's gone on for judicial review, not in the formal sense, but review by a court later on appeal, the original complaint, the original complaint in the 2018 case was all about underhand behaviour, deceit, telling lies to the court. And it was, by the time it got referred by the registrar to La Chambre, it's been kind of like polished up and buffed up to such an extent that it's now simply says the advocate misled the court. That's all it says. So all those kind of quite strong, passionate allegations that have been made have just been watered down. Say it's polished until it becomes something, I think, significantly different. And I feel for the complainant there, because I think that whatever actually got adjudicated on, either by La Chambre or ultimately by the Royal Court, was not how it started out. What the complainant lost their voice somewhere in that process. Anyway.
And they don't even have to do
No. I mean, I don't know. You could say that it's analogous to what the criminal prosecution. But I mean, even there, these days, prosecutors are supposed to be liaising with the complainant.
I was interested in case I was involved in, getting the complainants to understand that it was all in camera, and they couldn't talk about it. It was, you know, one part of our job, and it was quite a lot of attention to get them to understand what regardless of what's on this certain part of it, they were comforted about it. They couldn't even talk about it, that it was happening.
Yeah.
And they can click.
Yeah, I was going to, did they have to undertake announce to its correct, for example, they couldn't put it on?
I think, I can't remember, did they have to do that before? I don't think it was an undertaking, but they actually knowledge, this was knowledge that they understood.
Yeah.
They do that, yeah.
Well, there'll still be a problem with disclosure, you know, just generally disclosing the workings or the material, the evidence that would be presented. I think there'd be an issue maybe around committing an offence as far as that's concerned. So, yeah. Okay, so the decision, it will be a reasoned decision given in writing, which obviously then enables either the affected advocate or the registrar to consider mounting an appeal. It may dismiss the complaint, but if it finds the complaint is proved to that standard of beyond a reasonable doubt, we can see there its sanctions would start at the bottom with a private reprimand, moving up to a public rebuke. There could be a fine, as it says, not exceeding level 3 on the uniform scale, or being ordered to undergo specified training, which is a bit like that case that we mentioned earlier about the QC that had to go and be trained in advocacy and vulnerable people. Yeah. Okay. So as it says, if more severe punishment is required, so a fine on level 4 or 5, suspension for more than 3 months, or indeed disbarment, it doesn't itself have the power to impose those sanctions. So it has to refer the matter on to the Royal Court. It can also make an appropriate costs order. When it gets to the Royal Court, then, as you can see, the respondent has a right to be heard. There'll be an advocate instructed by the registrar, as there was in the 2018 judgment, and any one of those 6 orders can be made by the Royal Court. I've already made the point about who can appeal and who can't appeal. 28 days from the decision, although that can be extended.
And then it was available, and then you throw up so they made that.
Yeah.
So they went involved before in the actual decision making to appeal this one or not. Then because the 100% was found
and they had 9 jurats, I think, then.
Yeah,
yeah. They'll make it ironclad.
And they decided that, largely because they length of time, it should be handing over this aspect.
Yeah, mitigating factor, the delay. Obviously, it's stress, isn't it? It's a nasty thing to be hanging over you at all, but for a long time, it's bad. And that's the kind of, I mean, it's hard to say with what, like 3 decisions, but it is a kind of recurrent theme about how long these processes take. And you know, every time the court says this has taken too long.
Yeah. And part of the problem is going back to that 6 months thing. I think in these cases, the 6 months rule has been allowed to be
extended. Yes.
So it already is.
Yeah. Yeah. Well, I mean, it's supposed to be extended for exceptional circumstances, but again, there's quite a nice exposition of the reasoning, both for the original reasoning by the president to extend it, and then the court's kind of analysis of that, because it was the original proceedings here were matrimonial proceedings, and the explanation, they fell outside of the 6 month time limit, and the explanation was, I was advised by my advocate that you know, it could make these are unpleasant proceedings in the first place, and it could make them even more unpleasant if I start complaining about the opposing advocate, basically. So I was advised to wait until the end of these proceedings, notwithstanding there's a 6-month clock running down. I was advised to wait till the end. Well, the final step, I think they were within comfortably within the 6 months of the final step, but the Royal Court observes that the final step was a long time after the incident that was the subject of the complaint, and really kind of the main points have been done and dusted significantly before that, the final date of the last thing that ever happened in those proceedings. So even if it was acceptable and understandable that you wouldn't want to make things more difficult within the proceedings by just wanging in a complaint now, when we've still got a lot of other things to look at in ancillary relief and all the associated paraphernalia that comes with getting a divorce, that, you know, there was still plenty of time before that final decision that was made in the proceedings when you could have complained, and no one would have really freaked out about that, because there wasn't much left to do apart from dotting some I's and crossing a few T's, quite frankly. So the Royal Court's a bit critical of the President's enthusiasm, if I can put it that way, for relaxing the 6-month time limit, which again you can understand. It's well, apart from anything else, obviously the opposing advocate didn't necessarily realise that there was a whole idea of delay, didn't realise this thing was about to descend upon them. So you can't say they were stressed out by that part of the delay that was involved. But at the same time, you know, if you let 6 months go, people's memories are affected. You know, documents go missing. You know, it's a problem. Okay.
They say that, well, they don't say proven that doctors who get sued the most are the ones that have the worst bedside. So it's like, you know, they actually have a good relationship with their patient.
Victim.
They're less likely to get sued. I just want to do you see that Guernsey as well, in the sense that our advocates that get complained about are the ones that maybe just step ahead. Is there an element of that?
I don't know from personal experience. But what I've heard from where Tony was going through the time I've been involved in the ethics sector is that the advocates who get complained about most frequently are those who don't respond to their clients' request for information, who are in anybody's eyes, the ones who think they could do it clearly. They're the ones who are the most frequent. They're not keeping their clients informed, they're not responding, they're not dealing with the other side. And that's the most common complaint. And then filling in this with everybody else. And then I've had many people get to the time to create a complaint, because people will complain about you whether it's right.
Yeah, because you can see that just by the nature of that work.
Yeah.
Probably how I find out.
Yeah, certainly.
Yeah.
Where's the justice? You're working for peanuts and people are complaining about you. Yeah. Okay. Right, on that bombshell. Appeals. Well, we covered that, but you can see appeal on a point of law only on a point of law only to the Court of Appeal. And again, it's restricted to just the registrar or the respondent advocate. So if the complaint is completely out of the picture here, Court of Appeal may confirm or reverse the decision from the Royal Court and can substitute any disposal permitted by section 27 or 29. So in particular, those sanctions that we just identified. Reporting yourself for misconduct is not, you'll be relieved to hear, in the RPC. So as it says, this is one of those situations where you might call upon Rule 8. I don't know why you'd want to in this situation, but you might call upon Rule 84 and say that, in other circumstances, like the Bar Standards Board handbook, there is a clear requirement to report yourself. I think there is, yes. So as it says, you'd imagine that that principle should be applying, even if you have to go through using Rule 84 to get there. Poor service, we've already talked about service complaints, basically. Each firm has to have its own procedure for dealing with them. Not really much else to say about that, very straightforward. Should be informed about how to make complaints, and just to refer people to the website. I'm sure your website's blazing out how to complain about us, alongside how to contact us, just next to that. Okay, so I'm going to say not much else to cover, being bold. There's only, 3 pages of the study guide left. There's various appendices, but we've just got these 3 sets of rules to think about then. So, of which the most significant is the first one, then the advocates, I think the most significant, isn't it? The advocates' accounts rules. So, how to manage money then. So, you can see if you receive client money, that has to be paid without delay into a client account. There are some exceptions. So that's 7, 8, and 9. We can see that 7 doesn't have to be paid into a client account if it is cash, as it says that it's without delay paid in cash to the client or on his behalf to a third party or in the course of business. So kind of straight in, straight out, really. Money which must not be paid into a client account, so must not. I guess that's an important point. Rule 8. Money has been paid to the advocate expressly on account of costs, where a bill has been rendered to the client, or an advocate can apply under Rule 9 to the procurer for written authorization to withhold paying a client's money into a client account. That aside, you can see there's a definition of a client account in the first paragraph: current or deposit account at a Guernsey bank in the name of the advocate's firm, but also with the term client in the account name for ease of identification. Client money is also defined. Other things that can be paid into a client account: trust money, advocate's money or the firm's money, as may be needed to either keep the account open or indeed to open it in the first place. Money that you've taken out wrongly, contrary to the rules, that can be paid into a client account. Obviously, that has to be included here because it may well be coming from the firm's account or the office account instead. Check. Does anybody have checks anymore? You guys use checks? Yeah. Okay. It's not all bank transfers. No. Okay. All right. I haven't even seen a check I can't even remember the last time I saw a check, let alone used one. Anyway, yes, a check which includes client money or trust money, and therefore under Rule 3B, either must or, in the latter case, may pay it into. Sorry, other way around. May or must pay into a client account. So, other than that, obviously splitting money, if you receive a check, which clearly you do still, that may be like an aggregate check, but part of it's client money and part of it's trust money. So obviously it's technically difficult to split the check, apart from just ripping it in half, and that doesn't really work for the bank. So as you can see there, then if it's practicable to do it, you have to split the money and deal with it appropriately. Yeah. Mm-hmm. Yeah, no, I think. No, I think sorry, I haven't written it very clearly. So a check which includes client money may be paid into a client account, but if it includes trust money, it must be paid into a client account. Sorry.
So we're talking 2 separate checks.
Yes.
Right.
Yeah. Or 2 separate situations.
Yeah.
Yeah. All right, withdrawing money from a client account then. Can't take money out from a client account unless it's either permitted by Rule 5 of these rules, or you've got written authorization following an application to the procurer. So as you can see, money can be withdrawn in all of those circumstances, very straightforward. Trust money can be withdrawn if it's required for a payment in administration or in execution of trust, or it's going to be transferred to another account, which is exclusively for trust money. Other money can be withdrawn if it was paid in, again, for kind of maintenance purposes, or it was in a check that couldn't be split, or if you've made a mistake by paying it into the client account. Obviously, you can rectify that situation. Can only withdraw money from a client account under the signature of an advocate or a person who's been a full-time employee for at least 3 years. Yeah, well, you've got another example from the SRA there. I think it's fairly straightforward. Number of improper transfers into the office account, around £86,000, and yeah, breached 5 different principles from the Code of Conduct. Was eventually struck off. So as far as inspection is concerned, you have to keep proper accounts showing all the dealings, and they must be kept for a minimum of 6 years and made available to the procurer for inspection whenever required. And that's, again, kind of coming back all the way back to maybe the articles with the oath that talks about essentially being open and honest with your regulators. Not quite the language that he used. I'm using the language of the Fire Standards Board there, but open and honest with your regulator is a standard requirement, and that's an illustration of that fact. All right, advocates, obviously you've got these in the appendices. The advocates trust accounts rules, as it says, really are analogous or broadly similar as far as trust money is concerned to the requirements under the advocates accounts rules as far as clients money goes. It introduces, typo there, introduces that, the concept of the advocate trustee, and that's, as you can see, if somebody is both an advocate and either a sole trustee or a co-trustee with other partners or employees. And advocates accounts deposit interest rules, very straightforward, I think. So if you're holding client money in circumstances where it ought to earn interest, and that would be partly a function of the amount of money that you're holding and the length of time that you're holding it for, or likely holding it for, then you should pay it not into your standard client account, but an account that would actually earn some interest for the client. So it's the client that gets the interest, disappointingly. As it says, if you don't do that, you end up paying from your own money a sum equivalent to the interest that should have been earned by the client's cash. So as it says, Rule 1 is a judgment call, but in certain circumstances, Rule 2 makes life easier for our advocate. So if the sum of money that's being held is in excess of £3,000, that hasn't gone up since 1989 as far as I can determine. So if it's in excess of £3,000 and it's unlikely to fall below £3,000 within the next 2 months, then the rules deem that interest ought to be earned. So you need to comply with Rule 1, which either means you have to pay it into an interest-bearing account, or you're going to end up forking out for the money that you haven't earned on that. And I think that's basically that, really. So Jessica, anything that you'd like to chip in at this point? Or do you guys have any questions for Jessica? Because she is the fount of all knowledge on this subject.
One thing I've seen about questions is what's really important. Who your client is. Because you always have that kind of vagueness about who might be your client. If you've worked out who your client is, identify to the examiner who you're saying is your client. And having seen years for ethics you can think of. So it's hard to remember because there's lots of them about the sun comes in with the mountain it's going to be some of the money should be used for really important years and who then says really well. So it's not that sort of that sort of very practical, you like local rules quite practical the grand content.
Yeah.
Are we going to be given a set of anything?
I will put in chain some inquiries to see what, if anything. Well, we've had this conversation. No. Dozed off. Yeah. Well, for me, it's the point about the proceedings being inquisitorial, and that both the president and the registrar and La Chambre itself should be at the respective stages, should, particularly obviously La Chambre, because that's when it first becomes really, I guess, potentially adversarial, but should be very proactive in taking the lead. And that's why I'm saying that I think realistically, I can understand why you might not want the Guernsey advocate to be chairing La Chambre. I think there might be issues around that, but maybe getting your senior lawyer, your other senior lawyer, to be the chair, I think would make for a more effective process. Yeah. But I think that's the big message I think that comes out is the need to be proactive, to take the initiative. Don't just, because they do make the point that kind of with the best will in the world, the advocates kind of seem to be making decisions by agreement, which in other circumstances is fine and to be encouraged, but not in this particular. I mean, they said, the law says the procedure shall be inquisitorial. That's it, the end. So that, but there are lots of points I think that come out. It's a really interesting judgment, but for me, that's the main thing. Right, are we done? Excellent. Were you not here for that conversation? Yeah, which is good because I told her 9. Go on, come back. Yeah, how can that? Isn't that contradictory?
I think the reality is
Right, thank you all. So I'll see you at 10 o'clock apparently tomorrow then. I should be fully fed obviously at that point, which is good news for me. Boars, but they don't start doing breakfast until 8 o'clock on a Sunday, so it's a bit tricky if we start at 9 o'clock. Yeah. Anyway, so yeah, I should simply be an observer tomorrow, perhaps noting down any questions or advice that was given, but it's Kate Raby who is in the seat. So that should be excellent. Looking forward to that. But yeah, thank you. Likewise. Thank you so much.
Oh yeah, good luck.
Behold. Oh yeah.